Welcome to the Explainer. You know, every government wields this immense power. But who actually keeps that power in check? I mean, once the laws are on the books, who makes sure the government itself has to play by its own rules? Well, that's exactly what we're going to dive into today.
So who governs the government? I mean, that's one of the biggest, most fundamental questions you can ask in any democracy, right? If the government is the one making the rules, what's to stop it from just breaking them whenever it wants? The answer, well, it's not a person and it's not some secret committee. It's a powerful idea, the rule of law.
And just think about it for a second. How much the modern state really touches our daily lives. I'm talking about everything from issuing licenses and permits, collecting our taxes, to running our hospitals and schools. They handle planning permissions, regulate whole industries, and manage national security. But with that much power, mistakes and even abuse are kind of bound to happen. And a lot of the time, it's not even malicious. A government department can just get the law wrong, just like any of us can.
So, what's the safety mechanism? What stops a powerful government from just making up its own rules as it goes along, from going rogue? Well, there's a really specific legal process designed for exactly this. It's called judicial review. And this is where the courts step in to act as an impartial referee. Now, they're not there to write new rules. That's crucial. Their job is to make sure the government is playing by the legal rule book that's already in place.
All right, let's dig into how this actually works. The entire system of judicial review? It's basically built on one fundamental principle. It's got a Latin name that might sound a little intimidating, ultra vires. But trust me, the idea behind it is actually incredibly simple and really, really powerful.
So ultra vires, it literally just means beyond the powers. And here's what that means in practice. Any public body, whether it's your local council or a high-ranking government minister, can only do what the law specifically gives them the power to do. If they try to do something else, if they step outside the four corners of that law, their action is totally invalid. It becomes what's called a legal nullity. In other words, legally, it's as if it never even happened.
And this points to a really important default setting for the courts. See, judges start from this powerful assumption. They assume that Parliament does not intend to give the government some broad, sweeping power to just stomp all over our rights. If a new law is actually meant to take away a right, then Parliament has to be incredibly clear about it. They have to spell it out in black and white, no ambiguity. And then, of course, they have to face the political consequences for making that choice.
Okay, so staying within your legal powers, that's rule number one. But it's not the whole story. Judicial review also demands something else, that the government has to play fair. It's not just about what decision is made, but how it's made. And this brings us to this really core concept called natural justice, which itself is built on two simple, really ancient pillars of fairness.
Those two pillars are, first, the rule against bias, and second, the right to a fair hearing. And when you put them together, they make sure that justice isn't just done in some back room, but that it's seen to be done, out in the open, in the right way. So let's break each of those down.
Okay, so that first pillar is captured by another one of those great Latin phrases, nemo, judex, and res sua. And all it means is no one should be a judge in their own cause. It's pretty straightforward, right? The person making the decision can't have a personal or financial stake in how it turns out. They have to be neutral. And, this is key, they don't just have to be impartial, they have to look impartial to everyone else. The famous judge Lord Denning absolutely nailed it when he said this: "It's not always about proving that the decision-maker was actually biased. The real damage is to public confidence." Think about it. If a regular, right-minded person watches the process and walks away thinking, hang on, the referee was playing for the other team, then your faith in the whole game just collapses. It's destroyed.
Now that second pillar of fairness is every bit as important. It's called audi alterum partem, again with the Latin, but it just means hear the other side. You see, it's this fundamental idea that before a public body makes a decision that's going to negatively affect you, say revoking your license or denying you a critical benefit, you have a right to be heard. You have a right to tell your side of the story.
And Lord Mustill made a great point about this. It can't just be a formality, a box-ticking exercise. It has to mean you get a real opportunity to make your case. You should get to know what evidence they have against you, and you should be giving clear reasons for the final decision. At its heart, it's about the system treating individuals with basic dignity and respect. But what happens if a government body does everything by the book? They act within their legal powers, they give you a fair hearing, but the decision they come up with is just completely bonkers, just totally irrational. Well, believe it or not, there's a final safety net for that too. But I'll tell you, it is a very, very high bar to clear.
This is a ground of review called Wensbury unreasonableness, or more simply, irrationality. And this is absolutely crucial to understand. The court will not step in just because it disagrees with the decision. It's not about whether the judge would have done something different. For a court to interfere on this ground, the decision has to be, well, truly off the charts unreasonable.
So here's the classic test that a court will apply. They ask themselves, is this decision so outrageous, so absurd that no sensible person, acting reasonably, could ever have dreamed that it lay within the powers of the authority? So you see, it's not about being merely wrong or unpopular. It's about being utterly absurd, a decision that just completely defies logic.
Okay, so we've looked at the rules of the game. Acting within your powers, being fair, not being irrational. So what happens when the referee finally blows the whistle? When a court actually finds that a government action was unlawful, what are the consequences? And really, why does all of this matter so much at the end of the day?
Well, the process itself is pretty straightforward. An affected citizen brings a challenge to the court. If the court agrees that the action was unlawful, it can issue a remedy. And the most common and powerful one is called a quashing order. Now, this doesn't just tweak the decision, it completely wipes it off the books. It erases it. The decision becomes that legal nullity we talked about, basically hitting the reset button and forcing the public body to go back to square one and make the decision all over again, but this time lawfully.
And Lord Mustill, again, just captured this so perfectly. He pointed out that while we have elections and big political debates in Parliament, those things can't possibly police every single decision the government makes every day. Judicial review, he said, steps in to fill the dead ground. It provides that crucial, legal, and non-political check on the thousands of routine decisions that affect our lives.
And that brings us right back to where we started. Without judicial review, who would be the final referee on government power? You see, this whole process isn't about judges trying to run the country. It's about ensuring that the most powerful player in the game, the government itself, is also governed by law. It's the ultimate enforcement mechanism for the rule of law, proving that no matter how powerful an institution is, it still has to play by the rules.